everyone. I thank you all for joining, and I am both excited and apologetic to have the pleasure of joining you to discuss ethics for a whole hour. But I hope you've all enjoyed the conference. And I'm well aware that I'm one of the last speakers standing between you and the start of your weekend, so I will get on with it. I will note that I am a reformed IP lawyer. Once upon a time when I graduated from law school, I practiced IP transactional law as well as copyright and trademark litigation for a bit. So, okay, let's see now. Can we start the slides, please? I don't see them. If there's some technical difficulty, I can start them myself. Let's see. Okay, I can.
Caitlin just joined your panel,
okay.
And so she should be able to start them shortly.
Okay. There we go. Okay. Okay, fantastic. Okay, so ethics is such an interesting and broad word. So I'm just going to clarify that more specifically, I'm going to be talking about disciplinary law in the District of Columbia, which is really different than the disciplinary law in other states, for example, and even internationally, although there are certainly some commonalities there. So I'm going to do a few things this afternoon before I leave you all. I'm going to make a pitch for those of you who have been licensed in the District of Columbia for a number of years to consider serving as volunteer judges in our disciplinary system. I'm going to give an overview of our system, and then towards the end, I'll talk more about areas of our law that tend to surprise some lawyers, as well as a few fairly recent decisions by our board and court. I'm more than happy, would love it if you ask questions along the way. Some of this is really interesting. Okay, first slide, please. Okay, so this first slide just lists our board members. I'll discuss their role in our system shortly. They are all volunteers in the discipline system. All but two are attorneys, and the others are members of the public. And just, I see Ulysses Williams is asking a question. He is actually my brother, and he is also a Howard alum, came behind me. So we like to see about 5 years of experience as a practicing attorney with the bar. If you have, sometimes we'll allow attorneys to come in who are maybe recently admitted to the DC bar, but have experience elsewhere. Okay, next slide, please. Okay, so this is my office. We basically serve as in-house counsel to the Board on Professional Responsibility. We sort of refer to ourselves affectionately as discipline nerds because no one knows this stuff. I didn't know a lot of disciplinary law when I got to the office. So there's the executive attorney, I'm the deputy, and then we have some assistant executive attorneys and some staff attorneys and some other folks who support us in administering the discipline system. Next slide, please. Okay, so here's my plug for the day. We are actively seeking a diverse group of attorneys to serve as hearing committee members in the discipline system. And that refers to diversity in all respects: race, ethnicity, gender, practice area, in-house, solo practitioners, government, the list sort of goes on. We do get a number of cases involving intellectual property law, surprisingly, and it'd be great to have some lawyers with a working knowledge of that practice area to be able to pull from when we have those cases. If you're interested, my contact information is included on the last slide. I don't think I included it on the prior materials, but hopefully we can send those around if anyone's interested in joining us. Next slide, please. Okay, so every state and jurisdiction follows their own set of disciplinary rules. Some follow the ABA model rules, but DC follows its own rules. They are available here. Of course, the rules governing the conduct of practicing attorneys are listed under that first bullet you see. And the more procedural rules governing, for example, the disciplinary proceedings themselves are available under those latter two bullets. Next slide, please. Okay. One of the helpful transitions that COVID allowed us to make along with the courts was one to virtual hearings. We're still doing them, even though it sounds like indoor mask mandates are lifting and maybe some folks are going back. But I don't believe we'll be changing that at any time in the near future. So if you'd like to view one of the hearing committee hearings or to view oral arguments happening before the board, that link that I include there will take you to a list of all of those that we have upcoming, along with linking you to our YouTube page so you can watch them as they're streamed live. The courts, arguments before the court are stored on the court's page. Arguments before the board, I believe, are also stored for a period of time, but live hearing committee hearings are taken down. They're only able to be viewed live, and they're taken down once they're over. Next slide, please. Okay. So I'm going to start with a brief overview of the system to give you a sense of sort of who's who in the system. The DC Court of Appeals that sits on high established the Board on Professional Responsibility. While we don't work directly for the court, the Board on Professional Responsibility is the disciplinary arm of the court, which administers the attorney discipline system and supports the court in the adjudication of disciplinary cases. There are 9 board members, and you saw on the prior slide. 2 of them are actually members of the public and are non-attorneys. So that request for folks who are interested also extends to members of the public in the District of Columbia, with the idea that they are sort of consumers of our goods, the services that attorneys provide in the district. So we do welcome applications from non-attorneys as well. The board members are also volunteers. The hearing committee members and the board members are volunteers, and they serve 2 3-year terms. The court approves and appoints each of our board members. The board generally meets twice a month for 11 months out of the year. Then we have our hearing committees who are shown right below the Board on Professional Responsibility. They are appointed by the board, and they have the delegated authority to conduct hearings on formal charges of misconduct and contested petitions for reinstatement, limited hearings on petitions for negotiated discipline, and hearings on such other matters as the court or board may direct. I'll talk in a minute about what those different proceedings are, because they probably all sound like gobbledygook at this point. But the board approves and appoints each of the hearing committee members. Each hearing committee is composed of 2 attorney members and 1 public member. Just as with the board members, hearing committee members are eligible to serve 2 3-year terms in a row. So over to the right, you have the Office of the Executive Attorney. That's my office. And again, we support the hearing committee members and the board as they decide our cases. The Office of Disciplinary Counsel, you see on the lower left, they're also appointed by the board, and they serve as the chief prosecutor for attorney discipline matters involving active or inactive members of the DC bar. The respondent down to the right is just the respondent, just the attorney who responds to a disciplinary complaint against him or her. Next slide, please. Okay, contested disciplinary proceedings. So complaints in the top center. Complaints come in from a number of sources. I believe they come most often from clients, unfortunately, but they can also come from judges, opposing counsel, or any member of the bar, really. And disciplinary counsel will even open a matter based on an incident that it reviews in the media. So just to give you a sense of the volume of what we see, I have some old data that I need to update, but it's still pretty insightful. And I think it's been sort of consistent. In 2018, disciplinary counsel received a total of 1,114 complaints against attorneys, which is a lot actually for a jurisdiction as tiny as DC. It docketed 363 of those complaints and dismissed 677 of them. 74 of those complaints go through a streamlined process that disciplinary counsel provides for cases where there's a court-appointed attorney in a criminal matter. So if you look sort of to the right, that first drop down, the CJA complaints, that they have an alternate process. Docketed, which is in the center, versus undocketed complaints on the left. A complaint is docketed if 1, it is not unfounded on its face, meaning there appears to be an actionable claim based on the rules of professional conduct. 2, the complaint contains allegations which, if true, would constitute a violation of the rules of professional conduct and would merit discipline. And 3, it is within the jurisdiction of the board. So they would, for example, need to be a member of the bar. We do get complaints for some reason about lawyers who are licensed in New York or California, and those will not be docketed. Another type of complaint that we get that's not docketed would be complaints against judges, for example. All right. So a complaint remains undocketed and does not proceed further if, for example, the above factors I just mentioned are not present. Interestingly, we do get a number of complaints from clients about fee disputes, and we have sort of alternate, we have ACAB, Attorney-Client Arbitration Board. We have other mechanisms of dealing with those, and those do not proceed through unless there's some other issue with respect to disciplinary rules. They don't proceed through our disciplinary system. So a complaint remains undocketed and does not proceed further if I just mentioned, if those factors aren't present. So as you can see from the chart, if a matter is docketed, one of two things will generally happen. Sort of behind door number one, it can be handled with a diversion. So that's confidential discipline. It used in cases of minor misconduct, and the attorney does not end up with a record of formal discipline. There, the attorney acknowledges that disciplinary counsel has found a disciplinary violation and agrees to accept the diversion. And then a written diversion agreement is prepared for signature by both parties. That may include a requirement like a practice monitor. Once it is approved by a board member, disciplinary counsel supervises the diversion until a satisfactory completion of the diversion has occurred and disciplinary counsel's investigation can be closed. So that could be, they may not just a practice monitor, but they may need to take certain CLEs and shore up some of their understandings of what the rules require in different areas. So behind door number two, you have the hearing committee contact member who would review petitions, dismissals, deferrals, and informal admonitions, which are all listed there underneath the contact member. Petitions or specifications of charges are the charging documents that disciplinary counsel files. The petition must be sufficiently clear and specific to inform the respondent of the alleged misconduct and the disciplinary rule or rules alleged to have been violated. I'll talk about that in a little bit when I talk about due process issues. Dismissals, those might happen in a few different ways. One would be that after their investigation, disciplinary counsel's investigation, they find insufficient evidence to support the complaint. Another reason for a dismissal might be that there's a pending recommendation that the respondent be suspended or disbarred in another case. Okay, so we're down to informal admonitions. Those are letters written by disciplinary counsel admonishing the respondent for some form of misconduct, and that's usually minor misconduct. For example, if the attorney includes improper language in an engagement agreement, that might be the subject of an informal admonition letter. Or if there's commingling or something minor in terms of a trust account violation, if the attorney fails to keep records properly, all of those might be the subject of an informal admonition. But that discipline is made publicly available actually on the DC Bar's website, believe it or not. If you search an attorney's name, there will be a link that you can click on and see their prior discipline, only in the District of Columbia though. The respondent may not want to accept the discipline, the informal admonition. That happens. Sometimes they want to fight, and then disciplinary counsel files a petition and a specification of charges in the matter. It's fascinating to me. Sometimes we will see attorneys be charged with relatively minor misconduct, and they'll fight all the way up to the DC Court of Appeals, which takes sometimes years and quite a bit of resources if they're hiring counsel. So last, deferrals. Deferrals can happen in cases where there are proceedings pending elsewhere, like in a criminal trial. We get a number of those, unfortunately, and it would be more efficient to let that matter go before the disciplinary matter. Next slide, please. Contact member review. Okay, as I was just talking about the contact member review, they're only attorney members, and they review the specifications of charges mainly to make sure that the charge rule violations are supported by the allegations as well as the documents contained in their file. The specification must be supported by probable cause, which just means in our system enough evidence to lead a reasonable person to believe that a violation of the rules has occurred. So this slide here shows the authority that a contact member has really in terms of approving or rejecting a specification of charges. Next slide, please. Okay, if a contact member finds issues with the file, they usually will informally consult with disciplinary counsel to sort of understand the basis of their recommendation. And again, they have the ability to condition their approval of the spec based on some modification that they think it needs, and they can also reject them. Next slide, please. Okay, so an overview of the contested disciplinary proceedings. Next slide, please. Okay, so once the specification is approved and it's filed with our office, the Office of the Executive Attorney, then we all gear up for a contested case. Again, this slide just shows an overview of how cases move through our disciplinary system and end up before the DC Court of Appeals. But generally, most of them, once the spec is filed, or we refer to as a petition here, it goes before a hearing committee. The hearing committee writes its report and recommendation, and then that goes to the board on professional responsibility. And the board does the same thing. The board has authority itself to issue its own sanctions. So it can issue a public censure and things of that nature. The board also has the authority to dismiss a petition. That really, really rarely happens, but it does from time to time. And so, and then after the board takes its action, then it goes to the Court of Appeals. Next slide, please. Okay. You can just take a look. This is just a look at sort of our standard case track so that you understand how cases move through the system. Within 20 days the specification of charges being served on the respondent has to file their answer. Within 42 days of filing that answer, the hearing committee may hold a pre-hearing conference, although we don't do those very often anymore because the parties will often get together and decide on things like dates for exchange, all the discovery stuff, dates for exchanges of exhibits and witness lists and the like, and what days they're available to even do the hearing. And that's normally what happens at a pre-hearing conference. And so if they're able to do that and there isn't sort of a combative relationship between the parties, then we don't do a pre-hearing conference. Within 90 days of the pre-hearing conference, then the disciplinary hearing is scheduled. And interestingly, those cases, most of them last about a week. Some last a shorter period of time. And some have lasted over the course of months, interestingly, especially when there are witness availability issues or some issue pops up that someone didn't expect. The hearings can go longer, but usually they're around a week long. So within 48 days of the last day of the hearing, the parties will submit their briefs. And then the hearing committee generally has 120 days to file their report and send it over to the Board on Professional Responsibility. Next slide, please. Okay, the hearing. Okay, our hearings are bifurcated, which means exactly what it sounds like. Once the evidence is in and both sides have rested, the hearing committee goes into executive session and makes a preliminary non-binding finding as to whether any rule violation has been established. Interestingly, even if there's 10 different rule violations charged and 10 examples or 10 instances of violations of each of those rules, the hearing committee is not required to state which of the rules it finds has been violated. This process usually lasts just a few minutes, but sometimes it can take longer. If the hearing committee finds that disciplinary counsel has proven at least one rule violation, and it's non-binding again because they can change their mind, then the committee moves into the mitigation and aggravation phase, which I call the sanctions phase here. Their disciplinary counsel submits any evidence it believes should cause the respondent to receive a harsher suspension than would otherwise be the case. For example, if this is not the respondent's first instance of misconduct. And then the respondent has an opportunity to submit any evidence that he or she may wish to submit that would justify a more lenient sentence. For example, they may submit evidence that they were suffering from some sort of illness at the time of the misconduct, and the hearing committee can take that into consideration in making a sanction recommendation. Disciplinary counsel goes first and in the violations phase, and they bear the burden of proving their case, of course. There must be clear and convincing evidence that a rule violation has occurred, meaning that the committee has a firm belief that that rule violation occurred. And then, of course, the responding attorney goes next in responding to the evidence that disciplinary counsel has put in. Next slide, please. Okay. Negotiated discipline. Negotiated discipline proceedings are very interesting. They're a little bit different. The parties have already met. Often they have counsel, which is an interesting fact there. A lot of the respondents who appear in our disciplinary system are pro se. And everything, as you can imagine, just works far more smoothly when respondents have counsel. So, but they will meet prior to filing a petition. The respondent admits that they've engaged in misconduct. They're saying that they recognize they can't defend against the misconduct, that they would likely be found to have violated the rule. And they also agree on what the sanction is going to be. Next slide, please. Okay, so that's the process. The hearing committee generally approves the negotiated or recommends approval to the court of the petitions for negotiated discipline, so long as the admissions of misconduct and agreed upon sanction, so long as the petition supports the admissions of misconduct, so the facts make sense, are consistent, and the agreed upon sanction cannot be unduly lenient in light of previously issued sanctions for similar misconduct. So generally speaking, if the requirement is that if generally the court imposes 6 months, 7 months, 8 months suspension for a particular type of misconduct, the hearing committee will have some difficulty without a lot of mitigation or some very well explained factors in recommending that the court approve a sanction of 30 days suspension for similar misconduct. Next slide, please. Okay, you can go back for 1 second, please. Okay, so similar to the contact member review process, the hearing committee or the chair, if the full committee hasn't been hasn't been appointed, they review the file, they meet with disciplinary counsel to discuss any issues that they see. If the committee recommends approval, it actually skips the board on professional responsibility. It's one of those rare instances, and it goes straight to the court who makes the final determination. Okay, now next slide, please. Reinstatement proceedings. So these proceedings are how a respondent who was disbarred or suspended with the requirement that they prove fitness become members of the bar again. So disciplinary counsel can decide to contest or not contest a reinstatement petition. If the disciplinary counsel does not contest, then it goes straight to the court and we don't really get involved. If disciplinary counsel decides to contest the petition, then we have to hold a hearing. You can go to the next slide, please. Okay, in reinstatement cases, the burden is now on the attorney to prove by clear and convincing evidence that they have the moral qualifications, competency, and learning in the law to resume their practice. I had an interesting somewhat recent case where a respondent had been disbarred for, among other things, a fraudulent submission of vouchers for payment under CJA case to the Court of Appeals. And so dishonesty was sort of key in that case. And she was disbarred. I can't remember how long it was before she tried to come back in. It was more than the 5-year period. When she filed her petition to be reinstated, disciplinary counsel opposed it. And it was interesting because the court really dug into the fact that she, during her period of disbarment, had engaged in quite a bit of misconduct that was similar to the sort of dishonesty that was at issue in the original disbarment case. So they really do look at and focus on who you've been, how well have you kept up in the law, and really have you learned from your misconduct? Have you become a different person who would not do that again if you were admitted to the bar? So she had, sounds like maybe engaged in bankruptcy fraud while she was out. So needless to say, her petition for reinstatement was denied. Okay. Let's see. So if the petition is contested, we hold the hearing. And in that case, the burden is on the attorney to prove that they have the moral qualifications, competency, and learning in the law to resume their practice. So those are the focuses. Okay, next slide, please. Okay, interesting quirks and cases. I'm going to shift to talking a bit about our actual disciplinary rules and the sanctions for misconduct that tend to surprise our hearing committee members, and some that even surprised me when I started working in this office many years ago. Next slide, please. Okay. I was shocked to learn that that under Supreme Court precedent, disciplinary proceedings are quasi-criminal. The way that this plays out in the disciplinary system mainly is related to due process issues, and as I mentioned before. The system tries to ensure, for example, that the attorney has fair notice of the charges and the evidence against them. So that goes back to the contact member process there. You do not, for example, have a right to a speedy trial. I'm going to apologize because I'm going to read this because I think it's important, and it sort of is it shows the framework for how our disciplinary sanctions come into play. The United States Supreme Court has characterized lawyer discipline cases as adversary proceedings of a quasi-criminal nature, with the lawyer accordingly entitled to procedural due process, including an opportunity afforded for explanation and defense. I apologize for the ringing in the background. That phone never rings. That's in Ray Ruffalo. A disciplinary sanction differs from a criminal conviction, though. Although both protect the public, they do so in different ways. Most importantly, an attorney is in a continuing position of trust towards clients, the courts, and society in general. A member of the bar has accepted the onerous responsibility of participating in the administration of justice. This is the DC Court of Appeals saying, we grant the license to practice law as a privilege, not as a right, and we do so only on the strict condition that the attorney aspire to the highest standards of ethical conduct. Consequently, the purpose of a disciplinary proceeding is to question the continued fitness of a lawyer to practice his or her profession. In the words of the Supreme Court, upon review of a decision to disbar, the proceeding is not for the purpose of punishment. We see that a lot over and over in our cases. Our sanctions are not about punishment, but for the purpose of preserving the courts of justice from the official administration of persons unfit to practice in them. When a clear case of misconduct is shown to exist, the courts ought not to hesitate from sympathy for the individual to protect themselves from scandal and contempt and the public from prejudice by removing grossly improper persons from participation in the administration of the laws. Any betrayal of the trust which the attorney is sworn to keep demands appropriate discipline. A delay in prosecution without more cannot override this necessity. The contrary conclusion would mean that when licensing applicants, we would engage in a form of deceit. Our endorsement of an unqualified attorney would belie our simultaneous assertion that attorneys possess the integrity and competence which they must constantly demonstrate in order to earn the privilege of practicing law in the District of Columbia. And you see this language echoed in opinions across other states. I will note that one other interesting aspect of the disciplinary system that's being addressed in that last paragraph is the fact that delay is not a basis for dismissing a complaint against an attorney. We had a case not that long ago in Ray House where it's actually a prosecutor, and he claimed that because of the delay in prosecution, it had been 12 years that the case since the time of his misconduct, that it wouldn't be fair for the court to administer discipline. And the court said, nope, basically that's the language. It doesn't matter how long it's been. You're subject to discipline regardless. So and the court has never, ever dismissed a case based on the delay in prosecution. Okay, next slide, please. Misappropriation. Okay, the law on misappropriation is another area that continues to be very interesting to me and also to our hearing committee members, as it is one of the most serious charges that an attorney can be faced with. Believe it or not. So it's DC Rule 1.15A, safekeeping property. I believe every state has some iteration of this. A lawyer shall hold property of clients or third persons that is in the lawyer's possession in connection with a representation separate from the lawyer's own property. Funds of clients or third persons that are in the lawyer's possession, i.e. trust funds, shall be kept in one or more trust accounts maintained in accordance with paragraph 3. Other properties shall be identified as such and appropriately safeguarded. Complete records of such account funds and other properties shall be kept by the lawyer and shall be preserved for a period of 5 years after termination of the representation. What's interesting about this rule is that there are sort of three subcategories of misconduct involved here. One is misappropriation, which I'm going to talk about in just a second. The second is the requirement that an attorney keep their funds separate from entrusted funds. That's commingling, also a problem. And then the third is record keeping. And commingling and record keeping, going back to the informal admonition letters, we see those often where the disciplinary counsel is issued because they may see evidence an attorney keeps, for example, earned fees that they've taken too long to remove, and along with entrusted funds in the same account. But in order to violate the commingling aspect of this rule, they have to be in there at the same time. So we see that happen from time to time. As I note here in the bottom, at the bottom, oddly, there is no mention of misappropriation in the rule. I believe that there is talk of amending the rule to clarify that this is part of the rule and that this requirement is there, but that hasn't happened yet. And the talk has been going on for quite some time. So I suspect we'll see that at some point in the future. Next slide, please. Okay, so what is misappropriation? Many lawyers in DC and other places believe that it is theft. That is not correct. It is any unauthorized use of client funds entrusted to a lawyer. And I'll note here that it's not just client funds, it's any entrusted funds. So that could be If an attorney has a personal injury practice and they receive a settlement and they have the medical provider funds, hospital funds in there along with the client funds, all of those are considered to be entrusted funds for purposes of this rule. And misappropriation includes not only stealing, but the unauthorized temporary use for the lawyer's own purpose, whether or not she or he derives any personal gain or benefit therefrom. An attorney commits misappropriation when the balance of the attorney's account holding client or other funds, untrusted funds, drops below the amount that the attorney owes to the client and or owes to third parties on the client's behalf. There's no scienter requirement in the court's approach to misappropriation. It is a per se offense. And I'll talk about that in a second, because that's always very interesting and it's hard for folks to sort of process. In virtually all cases of misappropriation, disbarment is the only appropriate sanction in DC, unless it appears that the misconduct resulted from nothing more than simple negligence. Only if there are extraordinary circumstances will a sanction less than disbarment be appropriate in contested cases of reckless or intentional misappropriation. So there the court is highlighting that we have sort of three categories of misappropriation. Once it's found, then the court then looks to what kind of misappropriation occurred here. Okay. So yes, again, the misappropriation analysis is a two-step inquiry. First, the court looks at whether the funds went missing from the trust account without proper authorization. If the answer is yes, then we have misappropriation over and out. The next step is figuring out why they went missing. It's often easy to figure out that an attorney intentionally removed them for their own purposes. So you might see a lawyer removing entrusted funds to pay, for example, office expenses. That's disbarment. The next two categories, reckless and negligent misappropriation, that line is trickier. Reckless misappropriation results in disbarment, which is 5 years out, plus fitness, plus you have to come in and prove fitness to practice law. And negligent misappropriation will get an attorney a 6 months suspension, and they may not have to prove fitness to practice law. Next slide, please. Okay, the hallmarks of misappropriation. This is the court's term for sort of what the court looks at to figure out where that line is. So reckless misappropriation reveals an unacceptable disregard for the safety and welfare of entrusted funds, and its hallmarks include the indiscriminate commingling of entrusted and personal funds we talked about. And it's usually not a single instance. It's usually you'll see attorneys who are constantly sort of using their trust account, their escrow account, or even they're using their operating account and putting trust funds in there sort of without like over a longer period of time. There's often a complete failure to track settlement proceeds of their clients, a total disregard on the status of accounts into which the entrusted funds were placed. So they're not going back and checking and seeing what's going on in the account. And you may see repeated overdrafts. Also the indiscriminate movement of monies back and forth between the accounts, their operating account and their trust account. And finally, a disregard of inquiries concerning the status of the funds. So they may be on notice that there's an issue and they ignore it for over some period of time. A respondent doesn't have to have all of these factors present to have engaged in reckless misappropriation, but there are more factors, again, of what the court considers in determining where on the line between negligent and reckless the misconduct falls. Next slide, please. So two interesting reckless misappropriation cases here that one would think at first glance might be negligent, 6 months off, but were found to not be and were disbarment cases. The first case, In re Ahagotu, really taught us that it doesn't matter how long the funds were missing. Mr. Ahagotu didn't know what was going on in his trust account. He had basically lost control of it, and the funds went missing for less than 24 hours, I believe. No one got hurt, no client got hurt. He promptly put the funds back. He was disbarred, and again, meaning he was out for 5 years, which is significant, and then had to prove his fitness to practice law before he could be reinstated. And this is just a summary of that case. The court adopted the board's finding of recklessness, where the respondent attorney was proven to have committed just a single instance of misappropriation, lasting only 1 day because the attorney ignored problems with his trust account that started a year prior. So there's a notice issue. and because the attorney was the sole signatory on the account and at the time did not closely reconcile his records and bank statements. Mr. Gray was another respondent who lost track of what was going on in the trust account. And by all accounts, he was a great lawyer. Everyone loved him. No one had a bad thing to say about Mr. Gray. As I understood it, he thought he knew what was going on in the account. He had been tracking for a while, and then it turns out he stopped doing it in the same way, and he was just wrong about what was going on in his trust account. The court often looks at the notices that a respondent receives but ignores in deciding where that line between negligent and reckless is. And so here, as you can see from the description, he stopped tracking the funds that were in his trust account beginning in 2007. His record keeping became haphazard and incomplete. He allowed his accounting to lapse because his practice just became too busy. And if you asked him, he would not be able to know at any given time how much of the trust account belonged to him, i.e. Earned fees. And he made no attempt to reconcile, and he barely even looked at his monthly bank statements. The court acknowledged that although a good faith and objectively reasonable belief leading to the attorney's misappropriating of funds not yet earned from the trust account would be nothing more than negligent, generally. But what makes the respondent's belief objectively unreasonable here was his knowledge of his duty to keep his client's funds separate from his own, because he had been doing it before and then he stopped. Unlike some of these other respondents that we see that just, they don't know, and they need training, they take COEs and the like. But he disregarded beginning in 2007 that obligation, and he was no longer ensuring the safety and welfare of entrusted funds. So he was disbarred for engaging in reckless misappropriation, to my surprise, actually. Okay, next slide, please. Okay, negligent misappropriation. These cases usually involve a mistake. Negligent misappropriation is an attorney's non-intentional, non-deliberate, non-reckless misuse of entrusted funds, or an attorney's non-intentional, non-deliberate, and non-reckless failure to retain the proper balance of entrusted funds. Excuse me. Its hallmarks include a good faith, genuine or sincere, but erroneous belief that entrusted funds have been properly paid. Sometimes you'll see attorneys who think they've paid a client or think they've paid a provider, and they haven't, they've just been mistaken. And an honest or inadvertent but mistaken belief that entrusted funds have been properly safeguarded. Even when a wrongful disbursement is triggered by an honest mistake, it nevertheless constitutes a negligent misappropriation. So sometimes you'll see attorneys who transfer funds accidentally out of their trust account into their operating account and things like that. So that's what they're getting at. And again, negligent misappropriation ordinarily results in a 6-month suspension. Next slide, please. Okay, this was a really recent case. Actually, you can see it just came out February the 24th. And the court really clarified for us that a mistake falling under the rubric of negligent misappropriation may well be a mistake of law. Respondent's misappropriation of legal fees was negligent, where he should have understood when he received a flat fee from his client in 2012. It was 3 years prior to the decision in 3 years following the court's decision in Ray Mance, that he had to deposit that money in a trust account. I'll talk about Mance in just a second because it's an important case. And his failure to understand and conform with the Rule 1.15e as interpreted by Mance 3 years after we issued that decision clearly amounts to negligent misconduct. This case is interesting too because the standard is 6 months off, but here the board recommended and the court adopted that recommendation that he receive a harsher sanction. And I quote, in order to impress upon the district's attorneys that every lawyer, regardless of his or her employment, area of practice, or level of seniority, should read, become familiar with, understand, and adhere to the rules of professional conduct and the court's decisions applying those rules. So even though he didn't know, he got an extra ding for not reading the court opinions, which is also interesting. Okay, I will note that the backdrop of this case, as well as a few others that we now have pending in the discipline system, is in Ray Mance, where in 2009 the court decided the In Ray Mance case, which really turned our misappropriation law on its head from the perspective of many of our practitioners in DC. In that case, the Court of Appeals held that when an attorney receives a flat fee at the outset of the representation, Those fees are deemed unearned fees and remain the property of the client until they're earned, and they have to be held in trust. You could get informed consent from the client, of course, but there's a whole process for doing that. And it's not simply just saying you consent to my not putting the funds in the trust account and I'm going to put them in my operating account. And do you agree to that? Are you waiving your claims? That's not good enough. There's a list in Ray Mance of what you have to do and what you have to explain to your client. Because Mr. Harr did not know the court's holding in Mance when he received the flat fee payment, he couldn't comply with it, and he engaged in negligent misappropriation. Next slide, please. Okay, commingling. I've mentioned that a couple of times. It's another one that we see a lot of in our system. It is prohibited by one of those categories of Rule 1.15a, and it occurs whenever entrusted funds are in the same account with the attorney's funds, including earned fees. This case is particularly interesting, and it is now pending before the court. The board issued its opinion in 2019. Typically, commingling, if it's sort of a one-off or just a few instances of it, there'll be an informal admonition, which is the lowest form of public discipline. But as you can see in this case, the board recommended that Ms. Thomas Edwards be suspended for 2 years with the requirement that she prove her fitness to practice law, which again is a whole process that I just talked about, because she commingled her funds with her client's funds extensively and she didn't keep any records. So when disciplinary counsel went to do its investigation, it kind of couldn't make heads or tails of whose funds belong to whom. And that was really problematic and frustrating for the discipline system. So the sanction recommendation for her is pretty stiff. She also engaged in dishonesty when she filled out a pro hoc vice form. That's talked about in the case, but really the main driver here for the sanction was the reckless handling of the entrusted funds with the commingling and the lack of records. Next slide, please. Confidences and secrets. I like to flag this one too, because this is one that the rule is one that surprised me. Based on the plain language of this rule, even pillow talk to one's significant others is a form of misconduct when you are sharing confidences or secrets of your client. DC Rule 1.6, except when permitted under paragraph C, D, or E, those aren't relevant here, a lawyer shall not knowingly, one, reveal a confidence or secret of the lawyer's clients, two, use a confidence or secret of the lawyer's client to the disadvantage of the client, or three, use a confidence or secret of the lawyer's client for the advantage of the person or of a third, for the advantage of the lawyer or a third person. Confidence refers to information protected by attorney-client privilege under applicable law. No shock there. But secret refers to other information gained in their professional relationship that the client has either requested be held inviolate or the disclosure of which would be embarrassing or would likely be detrimental to the client. So those latter two categories, are pretty interesting. We recently had a case where a lawyer was found to have violated this rule because she shared a confidence that she learned in the course of representing her client with her boyfriend. And I didn't include that one because it was just decided by the hearing committee and is still pending before the board, and we don't have the board's recommendation yet. But it is a very interesting case that was brought by the office, and I'll admit that she admitted the rule violation. So I do expect to see, as that one moves up through to the court, that will be deemed a violation. So interesting. Next slide, please. Okay, I did include this case. This is in Ray Keck, because it makes clear that it applies to in-house lawyers. Oftentimes we see solo practitioners or practitioners at sort of smaller law firms that come through our system. It is not generally the case that we get our in-house folks or even lawyers at big law firms, but this case did involve an in-house lawyer who shared confidential information from her corporate client with a news reporter after she left that position. She also shared it with the U.S. Attorney's Office and the SEC. And so she received a 60-day suspension for doing that, and for that violation of Rule 1.6. So that's an interesting one. Next slide, please. Okay, dishonesty. We also see a fair number of cases involving charges that an attorney has engaged in dishonesty. So we actually have a couple of rules that govern dishonesty with Rule 3.3. I believe it's 8.1 as well, but this is sort of the broader rule. Rule 8.4c, it prohibits conduct involving dishonesty, fraud, deceit, or misrepresentation. And those are actually 4 separate categories of misconduct, and there's law under each one of those in terms of what that means. They generally mean what you would think they mean, but in terms of the facts that disciplinary counsel has to prove, they differ. The court takes this very, very seriously, although arguably less serious than our sister jurisdiction in Maryland, because an attorney actually can be disbarred more easily there than here. Next slide, please. Okay. Lawyers have a greater duty than ordinary citizens to be scrupulously honest at all times, for honesty is basic to the practice of law. Every lawyer has a duty to foster respect for the law, and any act by a lawyer which shows disrespect for the law tarnishes the entire profession. That's the court statement in Re Cle Verification, and it is, I see this language in court opinions weekly. They're very serious about lawyers being honest, which is interesting. That surprised me. This level of seriousness that the court takes it. So the sanctions here for dishonesty, they really vary wildly. It can be as low as a public censure if it's just a single instance of a misrepresentation, or even a brief suspension, particularly if it's sort of dishonesty to a court. But if there's dishonesty with other rule violations, that may be even a brief suspension as well. If it's pervasive or it's considered egregious, then there are more severe sanctions, and we're talking about years. Finally, if the court decides that the dishonesty is of the flagrant kind, because it's extensive and protracted, then an attorney may be disbarred. Next slide, please. Okay, so that's our disciplinary system. I hope everyone isn't asleep by now. Again, I really encourage those of you licensed in DC to consider joining us, and I'm happy to answer any questions that you may have or to let you get closer to your weekend. But I thank you so much for joining and for listening.
Thank you so much, Aisha. I'm not seeing any questions in the chat, so I will just say thank you so much for joining us today and for providing that very thorough and interesting presentation on the DC Bar. I might actually sign up to be a volunteer. I have to see if I'm still active, because, you know, working for the federal government, I only need one. But if I am, I'm like, I might just do it. So you got one. You got one.
I appreciate that. Thank you. And thank you for having me.
All right. And for everyone that is looking for CLE credit, let me just share my screen. The CLE verification code for this session. So CLE verification code number 6 is empowerment. So for the ethics session, once again, the CLE attendance verification code number 6 is empowerment. At the end of today's session, you'll receive an email with a form so that you can submit that information in order to confirm your bar information for CLE purposes. And now I will turn it over to the final speaker for the day, Professor Lateef Mtima, to provide some closing remarks.
Well, thank you, Tasha. And, you know, I'm sure it was not lost on our attendees, your skillful utilization of our IP social justice lexicon as verification codes. I mean, talk about having IP social justice just running through your veins. This has just been an extraordinary day. We've learned so much, and it's a day in which we collectively are deserving of some self-congratulation. One of the things, of the many things that occurred today that is so noteworthy to me, is that in our last presentation, our ethics presentation, I believe that for our CLE program, and maybe for some others, we have established an interesting record, because I don't know if it was said because I had to step away for another conflict for a few minutes, but one of our opening sessions we had for the in-house counsel we had a panel of Howard alum. And of course, for this final ethics session, we had a Howard alum, but we had a brother-sister combination because there was no coincidence of the Williams last name. So we had two members of the same family, brothers and sisters, Ulysses Williams, and then we just were able to hear from Aisha Williams. And maybe next year, because there's a third who also is a Howard alum, and maybe next year we'll be able to bring her in. As you can imagine, as this has just been such a fulfilling experience for all of us today in bringing to all of you for the 19th consecutive year a program that was conceived, as I said it from the outset, long before diversity, equity, and inclusion was ever considered in the intellectual property context. Indeed, when we at Howard and at the Institute first coined the phrase of IP social justice, most practitioners responded to us as if that was simply an oxymoron. And thanks to the collective efforts and the support of the grounding support of Tom Irving and Esther Lim and the late Don Dunner, that helped us bring this vision to fruition, we've now had almost 2 decades in which to perfect it. And I think that what we saw from today is that, well, I won't say we're perfect because then we won't have anything to strive for, but I think we've gotten pretty darn close. So with that, I am not going to keep you from the very well-deserved weekend that now awaits you. I would like to thank all of our sponsors once again, and again in particular, our specific special CLE sponsors. As you see from our website and materials, we have a whole collection of sponsors, many of whom were specifically Tech Summit sponsors, and some were specific to the CLE and some to both. And that includes Google and Visa and Finnegan and Perkins Coie, and all of our sponsors have been able to make this 2-day conference a possibility. And of course, we always have deep gratitude to the members of the bench who enable us to have that anchor judicial panel. And again, we're very grateful to Esther Lim and Scott Burwell for organizing that and making certain that we have that the Don Dunner judicial panel each and every year. So with that, I believe that we have covered more ground than anyone could possibly think we could cover in a single day. We had fantastic presentations. I believe we've lived up to the promise and the intention of what we tried to do with this program, again, almost 20 years ago. Our vision was that at that time, whenever you went to IP continuing legal education programs, you rarely saw presenters of color. You saw some women presenters, not very many, and almost no presenters of color. And because I was one of the few who had the privilege of being in those programs, I just thought that the time had come for us to create a program in which we could showcase attorney of color achievement and accomplishment in the field, and at the same time create and put forth a continuing legal education program that would be inviting to attorneys of color and women who were not yet in the field, and make them feel that both because they could see people who looked like them, but also because of the issues that we covered, the way we approached intellectual property, both as an engine for progress in society, but also in terms of its social justice obligations and effects, that it would make people who would not otherwise think that intellectual property law was for them, that they could see themselves and they could see their place and they could see their dedication to society and social justice objectives as being a part of that endeavor. And I think if you were here for today's program, you saw diversity, equity, and inclusion, and above all, you saw first-rate expertise all across the board. So with that, I want to thank all of you for joining us today. I want to thank our program co-chairs, Esther Lim, and of course, the indefatigable Tasha Bunch. I don't know how she does it all, but somehow or another she does it. And all of you who joined us as attendees. And if you thought the first 19 years were impressive, as I said this morning, mark your calendars. Next year is the big 2-0, our 20th anniversary. We have some extraordinary things already in the works for that great occasion. And I look forward to seeing all of you next year, and very much hopefully, yes, indeed, it means cake, and very much hopefully all in person so that we can share thoughts, break bread, and clasp hands all together through this incredible journey of intellectual property and social justice. So thanks very much. And Tasha, I think that can take us out in terms of whatever else you have that we need, any housekeeping that we need to think about.
All set. The emails have been sent regarding CLE credits, so be sure to check your email and spam mail, and everyone have a wonderful weekend.
Thanks very much. Bye.